Hi, I'm Mother Mary. I cover the state of justice in America and in the world. And today we are going to read Chapter 1 of Alaska's Organized Government Corruption: How to Expose and End It, written by David Haig. New information. Recently, a source provided outside information on what is contained in the sealed 2021 to 23 Kenai Grand Jury report and recommendations that they wrote after their 2-year investigation into organized judicial corruption in the state of Alaska. It quotes the report documented corrupt government activity judges appeared to be covering for each other and for the system itself. This confirms citizen fears that Alaskan judges sealed the report recommendation to cover up for corrupt judges and organized judicial corruption. The background: for decades, evidence mounted of organized corruption taking root in Alaska's judicial system. Citizen efforts to address this through traditional agencies or officials like the courts, the FBI, and others met a brick wall of denial and refusal to investigate. In 2017, citizens realized that grand juries were enshrined in Alaska's constitution to investigate public officials when other agencies refused. In Alaska Constitution, Article 1, Section 8 states the power of grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended. Commentary to the Alaska Constitution preamble: the grand jury is preserved for all purposes, particularly for investigation of public officials. Citizens go through years of hell just to get an investigation. Judge Jennifer Wells ordered the first Kenai grand jury to stop investigating and permanently dismissed them from service after the majority voted to investigate government corruption. Citizens organized a peaceful courthouse sit-in to be continued even after closing time and until the grand jury was re-impaneled and allowed to investigate. The day before the sit-in, citizens were informed a Kenai grand jury would be allowed to investigate. Kenai grand jury goes through hell. FOIAs show the Alaska Supreme Court conspired with Attorney General Craig Taylor to issue Supreme Court Order 1993 to unconstitutionally cripple the grand jury in the middle of their investigation. The jury tried forcing the Supreme Court to testify about this. A vanished juror, still not found to this day, was used to dismiss the jury's indictment of a judge. Conclusion: one way to address this is to obtain the original grand jury report and recommendations document. But since recordings prove the Kenai grand jury was intentionally provided corrupt counsel, the report recommendation is unlikely to fully expose and uproot the corruption. But New York City residents found another way to combat government corruption. They did, in 1994, the Mullen Commission, which was appointed by Mayor Dinkins to publicly investigate. Quote, to cover up their corruption, officers created even more. They falsified official reports and perjured themselves to conceal their misdeeds. In the face of this problem, the department allowed its systems for fighting corruption virtually to collapse. It had become more concerned about the bad publicity that corruption disclosures generate than the devastating consequences of the corruption itself. As a result, its corruption controls minimized, ignored, and at times concealed corruption rather than rooting it out. Such an institutional reluctance to uncover corruption is not surprising. No institution wants its reputation tainted, especially a department that needs the public's confidence and partnership to be effective. Since no entity outside the department was responsible for reviewing the department's success in policing itself, years of self-protection continued unabated until this commission commenced its independent inquiries. Requests that included borough mayors to meet with Alaska's governor or attorney general have been unsuccessful, even though it was simply to present evidence requiring appointment of a Mullen type of commission. Deputy Attorney General Corey Mills claimed neither she nor Attorney General Craig Taylor has authority to investigate corruption. There are video and evidence of this at alaskastateofcorruption.com. I'll put that link in the description box below. Because it took a looming sit-in to obtain a grand jury investigation, citizens believe it will take another to obtain the report and recommendation in a Mullen-type commission. Citizens are organizing a peaceful sit-in at noon on December 11th, 2026, after Alaska's new governor takes office, in the Robert B. Atwood building in Anchorage, where our governor's office is located. Until citizens receive the report and recommendation, and until she or he appoints a Mullen-type commission, they are organizing forums at which the governor candidates will be asked about the above and what they pledge to do if elected. If you are willing to join the sit-in, can help with forums, or ask candidates to pledge, please text or email your name, phone number, and email address. I'll put that contact info in the description box below. This battle will decide if we, the people, rule government or if government rules us. We must see what our brave Kenai grand jury wrote to us after their 2-year-long investigation into organized government corruption. We must demand an independent commission publicly investigate the forces that assaulted and overwhelmed our brave Kenai grand jury. How about find the missing juror? That was my ad. It's time for the sleeping giant to wake up and take charge. This and future articles containing facts which should galvanize citizens into action and hard evidence of corruption will be archived at the alaskastateofcorruption.com. There's also ultimately going to be a link where you can donate. Thank you for listening. Have a great day.